Oops. Okay. We will see today all the laws and regulations applicable to the real estate process in Mexico.
I like law.
Please turn off the microphone, please. Some of them are the political constitution, the federal civil code, the state civil code, PROFECO law, money laundering law, federal forfeiture law, consumption tax law, which called EVA law, the ISR, which is the capital gain law, federal tax code, agrarian law, law for the registration and for the register and accreditation of real estate agent in the state of Jalisco, federal law for the security on credit operation, and others, some others. Okay, so let's see. What we're gonna discuss is what comes in the laws. For example, the particular article that say something about the real estate. So first, let's go to the political constitution of the Mexican United States. That is the real name. Mexican Estados Unidos Mexicanos. That is our name, the name of our country. The Mexican United States. Okay, the 127 article, it says that the ownership of the lands and waters within the limits of the national territory originally belongs to the nation, which has transferred the ownership to the individuals constituting the private property. That's so it's very clear, isn't it? So the ownership of everything, it belongs to the state. And they transfer the ownership. Okay. And let's see what says the Federal Civil Code. Can somebody help me to read, please?
You want somebody to read it in English? Hugo?
Yes, can you help me to read?
Yes, I can do it. The Federal Civil Code is a legal framework that applies throughout the Mexican Republic in matters of a civil nature at the federal level. It serves as the primary source of regulations that structure civil law. Civil law has 5 main formal sources. It's too small. Legalization, custom, jurisprudence. What
Yes,
did I
go
say?
ahead. Go ahead.
Doctrine and general principles of the law.
Whatever it
person,
doesn't make sense, just let me know.
Okay, yeah, it's just small and okay. Every person, whether natural or legal, is considered an individual of rights. Civil law is responsible for linking the rights of these individuals, treating them as particular entities rather than as a collective whole. The Civil Code is a systematic set of legal norms that regulates various aspects of social life, such as marriage, birth and death registration, domestic violence, and provisions regarding property, possession, inheritance, obligations, and contracts. These include lease agreements, sales contracts, mortgage contracts, among others.
Yeah, thank you. This law is supplementary to the state laws. So they are complement the federal and the state law. So if something is not very particular here, we're gonna find it in the state civil code. Let me turn off my phone. We're gonna read each article of all the laws I already showed you. all this, okay? But just the ones that has to be with the real estate. For example, in the Federal Civil Code, the Article 750, it says that the real property are considered the following items: the land and any constructions attached to it, over it. Number 3, anything permanently attached to a real property in such without damaging excuse me. Any permanently attached to a real property in such way that it cannot be separate without damaging either the property itself or the object attached to it. And number 12, it says the asset and rights over the real property. Let's see, for example, houses, all type of construction, for example, property. For example, any kind of goods. For example, properties. For example, lands. For example, investments. Whatever it can consider as an asset or also a right. Assets and rights. What is assets and what kind of rights? What kind of rights? Well, I already wrote 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 different rights. The possession is the provisional prevalent what is susceptible to appropriation. That means probably anybody has a possession or something or a property, but he has not it's up to approbation, to a trial. Okay, that is the possession. It's not the real owner, but the person has the possession. That is a right. Another one is the usufruct. It's the person who enjoy assets that belong to another. That is the usufruct. Ownership is the right to ownership of an asset. Number 3, use. The right to use is the right to use assets that own to somebody else. The right to surface right is the right to planting or building something in a land that belongs to somebody else. Easement, which called servidumbre, because in Spanish servidumbre, it's like the right to pass through to one land to another. That is one kind of servidumbre or easement. To pledge, when it's delivered, a pledge as a warranty. Retention is the right to retain an asset as a security. And mortgage is the right to be paid with a guarantee. And antichrisis, when it is delivered goods as a guarantee. So these are 10 different type of rights, which also is real estate. All this it's considering as a real estate. Is there any question here? The Federal Civil Code and the Article 773, it says that foreigners and legal entity wishing to acquire ownership of real estate property must comply with the provision set forth in Article 27 of the Constitution of the United States Mexican state and its regulatory laws. Remember this, the number 20, here is the Article 127. Article 785. It's about the vacant properties. Refers to real estate that doesn't have a certain known owner. It probably is ownerless or abandoned ones. In the Código Civil, Civil Code, it is established that the provision of this code will serve as supplementary law to all state legislation. Which one of the laws are the highest, the top of the laws? The Constitution. Any law can be up over the Constitution. So all the laws are supplementary one to each other. Article, this is a very long one. Article 799. It's about the real property by nature. For example, the land and construction attached to it. For example, the plants and trees. That trees or plant that is really attached to the ground. Anything, number 3, anything permanently attached to a real property in such a way that it cannot be separated without damaging either the property or the object attached to it. For example, any kind of equipment, any construction, a terrace, a pool, swimming pool, whatever, all that. A statue, relief, paintings, greenhouses, pigeon loft, beehives, fish ponds, or similar breeding grounds when the owner maintains them with the intention of keeping them permanently attached to the land and forming a part of it. Machines, vessels, instruments, tools, fertilizers intended for the, let's see, check the number 7. Fertilizers intended for the cultivation of land, even if it is not set on the ground. I mean, if you have the material, the product there, it belongs to the property. Mechanisms powered by any type of energy with or without computing system, or used to harness air currents. All these are considering real property by nature. Thank you, Vanessa. Thank you. Thank you, because you already sent the file. Number 9. Springs, ponds, cisterns, water courses, as well as aqueducts, ducts, any kind used to carry liquids, gases, or energy. Working animals too. Digs and structures that, even if floating, are intended by their nature and conditions to remain fixed at a point on a river. Real rights over the real property. Rolling stock, not rolling stones. Plants, facilities, or establishments for the use and exploitation of the concession. All these are considering real estate property by nature. Article 816, common use property. Remember the common use as it is the social property, the ejidal properties. See? The common use property is inalienable. I mean, no one can sell the properties. How to say, a menos, at least, or only by regularization, that kind of property, bring it the social property to private property. It's a process. But anyone, no, they cannot sell the property. They can only sell the rights. Article 821, acquisition of real property by foreigners and legal entities. Foreigners and legal entities wishing to acquire ownership of real property must comply with the provisions set forth in Article 27 of Political Constitution of the United Mexican State and its regulatory laws. It says that in chapter number 1, it says that only Mexican by birth or naturalization and Mexican corporation have the right to acquire ownership of land, water, and their accessory, or to obtain concession for the exploitation or mines water. Well, it says that article comes since 1917, in the year 1970. So it's very old. That is very old, that article. In 1992, they come a change that changed all this article. It says in number 7 that the legal personality of the Ejido and Communal Population Center is recognized and their property rights over land and are protected. So it says that the article says that only Mexican by birth or naturalization and Mexican corporation have the right to acquire ownership and land, but with some mechanism, foreigners can acquire properties in Mexico. Okay, the Civil Code of the State of Jalisco in Article 822, it's about ownerless property. It includes movable items like or animals also. For example, stray animals roam the streets freely and fend for themselves, or a property abandoned. So that is the ownerless property. A vacant property, it's refers to real estate that does not have a certain or known owner and is found to be abandoned. Article 834, it says that discovery of vacant property. Anyone who becomes aware of the existence of vacant property in the state and wishes to acquire the share granted by law to the discoverer must report it to the agent of the social attorney office at the location of the property. That is pretty much the way to acquire the property. In case of animals that which is abandoned, they can actually inform to the for example, not a dog or cat, probably a cow that is free on the street. First, they have to report to the agent at the social attorney office in each city. Article 879. This is very important. This is a good one. It's about usucapion. I'm not sure if it is right, usucapion, but in Spanish it's usucapion. It's the adverse possession action or the acquisitive prescription. The adverse possession, it means is the way to acquire an ownership and other real rights over a property through possession with the intent of ownership for the time period and under the conditions specified in this code. The Article 889, it says that it's necessary the possession for usucapier. Usucapion. In Spanish, the verb is usucapir. That is the verb, usucapir. The possession necessary to claim adverse possession must be as an owner, number 2, peaceful, number 3, continually, and public. This one is the legal right allows anyone who has come to possess an asset. It can be movable or immovable, to be declared as an owner by judicial resolution, but without having completed the process to do so. The verb possession in Mexico is it needs the necessity to prove the possession as an owner. Article 890 says that completion of adverse possession for real estate property or the adverse possession of real property is completed. Number one, in 5 years, when the property is possessed as an owner in good faith at the time of acquisition, peacefully, continually, and publicity. Everybody, it means that everybody knows that that person has possession of that property. Number two, in 5 years, when the property has been subject to possession registration. Number three, in 10 years, when the property is possessed in bad faith, but in the capacity of an owner. Peacefully, I mean, probably they possess in bad faith the property, but it becomes peacefully during the time and continually and publicity. And number four, the time specified in section 1 and 3 will be extended by 1/3 if it is proven by anyone with legal interest that the possessor of rural land has not cultivated in during most of the time they ever possess it, or if the possessor of urban land has not made the necessary repairs and the property is remained uninhabited for most of the time it has been in their possession. So most important thing here is the possession that is peacefully, continually, and public. That the possession is public. No, in fact, in the next 5 years, they can start a trial to make it real, the uso capión. Any questions? Article 892, possession acquired by violence. When possession is acquired through violence, even if the violence ceases and possession continues peacefully, the time period for adverse possession will be 10 years for real property and 5 years for movable property, counted from the moment when the violence ceases. Article 931, good faith construction, planting or cropping. The owner of the land on which construction is made, the owner of the land on which construction is made, or whether crops or plants are cultivated in good faith, has the right to claim ownership of the work, crops or plantation, upon payment of the price of the seeds, plants, or material used, or to require the builder to pay for the land occupied by the construction. If the person planted or cultivated, only the rent will be charged. If the lander acts in bad faith, they will only have the right to be paid the value of the rent of the price of the land in the respective cases. Article 932, bad faith construction, planting or cropping. Anyone who builds plants or crops in bad faith or on another person's lands loses the work, the plants, or crops without the right to claim any compensation from the landowner, nor to retain the property. Article 939, land adjacent to lagoons or ponds. Owners of property adjacent to lagoons or ponds do not acquire land rivaled by the natural decrease in water levels, nor do they lose the land that becomes flooded by extraordinary water rise. Is that everybody's clear or any question? Condominiums. Article
John,
1000. Yes.
I have a question.
Okay, which one?
The other day we were talking about adverse possession. If someone owned a property on the lake, for example, and the lake receded, and that land in front of their property could be claimed. My question is, where does the federal zone begin and end? If the lake recedes, does the federal zone recede? And what happens if the water comes up past the federal zone onto my land, say? It's the same sort of thing as you've just mentioned in relation to lagoons and ponds.
Which one? It's in this article, isn't it?
It's not, we haven't covered it today, but we talked about owning a piece of land on the edge of the lake, and the lake recedes,
Oh, yeah.
and someone and you could claim that land, but someone else couldn't. I'm just wondering where the federal zone comes into that equation.
Well, the federal zone, it begins. There's a ministry, which calls Semarnat, I think it's Semarnat, that they have the lines, the end lines. When the lake reduce the surface, even in that the area is not still being federal.
Oh, that's what I thought,
Federal.
yeah.
During the time, if the lakes, for example, it dries forever, probably could be start any kind of trial to possess or to buy from the federation, because that area, that particular area, belongs to the state. So that is not
Are there
really
maps that show the extent of the federal land around Lake Chapala, for example?
For example, Chapala. They have already the end line, the edge of the lake. It's sometimes the weather works to reduce or to increase the surface or the volume of the water. So the water sometimes you're gonna recognize, because the water is owns that area, for example, river or a lake. So, but the edge in that particular ministry, that is Semarnat, they have the edges, but they can move. The edges can move. For example, in the beaches, if the edges move, then they can start to buy or to usucapier the surface, but you have to wait for some kind of time, any time, and start a trial. Not that is not for free. Is that there is the surface, there is the land, and it's yours if you want, because anyone who's the first person that has right to own that part or that area? The owner in front of the lake, not the one that is behind. The owner in front of the lake, the river, or the beach is the first one in the line to usucapier that area.
Okay, thank you.
But it has to be legal. You have to make something
And does the 5-year and the 10-year clause come into that as well?
No, that is
No.
one. That one is different. It's in another
It's
law.
different. Mm-hmm.
It's different.
Okay. Okay, thanks.
Thank you, Alex. Good faith, contaminants. Article 1002. Classification of contaminants based on the use of common elements. The classification is about the common elements in regard to the operation and utilization of common elements by one or more contaminant units. Well, actually, it's not if it is just one owner, but it could be a contaminant with one owner because he owns all the units. It's not but it's impossible that is a condominium. It needs to be two or more. I'm not, am I clear with that? They are classified as either simple condominium or composite condominium. Article 1003, classification of condominiums based on distribution of common and private areas. Based on distribution or common and private area concerning the land and the buildings, and they are classified as horizontal, vertical, or mixed. Horizontal, vertical, or mixed. Could be a condominium with both. What is a duplex? Have you ever heard duplex? What is a property? Duplex properties? It's like the ones in the image. It's two houses. The land and the common areas belong 50%, 50%, 50-50 to each owner. And they own the facade, the roof, the parking lots, and the garden in the back. They own everything. Only they own as exclusive the part that is into the house or the those are houses. No, it is not considered as a department. Are considered houses. That is duplex. Sometimes they in the last times the developers are building three levels of house departments, but those are not triplex. Those are condos. Okay, those are condominiums. These one are just duplex, and they have their own condominium regimen. They have a deed, the condominium deed. Okay, usufruct. Article 139. Usufruct is the real and temporary right. Temporary right to enjoy another person's property without altering its substance or form, unless otherwise agreed. That is the usufruct. They can use enjoy the property. Article 1044, creation of usufruct can be established from or until a certain day, purely or under condition. You can create usufruct, but it has to be protocolized over with a notary public and registered at Registro Público de la Propiedad. Article 1097, extinction of usufruct. An usufruct is extinguished. How can I pronounce it? Extinguish or extinguish? Extinguish. I think it's extinguish.
Extinguished.
Timeshare. Usufruct extinguished. It could be by the death of the usufructuary or by the expiration of the terms for which it was designed. Timeshare. It's the right to use in timeshare is the legal regime under which building and its furnishings are designed for use with the purpose of being used by touring purposes. Well, it says only by touring purposes, but jointly and separately. And it means the furnishing and the building, and successively by the purchaser, who shall be called shareholders, and the others affecting the property called the affectors. Laws, Article 7, real rights, it means derecho real, is the real right. A real right is the legal power that its holder has over a property. It is preferential, enforceable, and opposable to third parties. Article 316, spouse as guarantor. The spouse who is legally a guarantor of or surety shall be liable with their own property, just with his part, with a portion of the social estate that correspond to them. In Mexico, we the regime we have marriage regimen for the marriage that is common or separate. So when it's common, when it's separate, it doesn't matter if somebody legal take it is liable with the property, okay? But when it's common, it's only with the portion of the social state, the part of that correspond to him or her or him or whatever. Eviction, 1622. Eviction occurs when someone who acquires a property is deprived of all or part of it through a judgment that becomes final. Article 1623 gives you, it's gonna give us more information. Anyone who alienates property is obligated. Anyone who sells a property is obligated to respond for eviction, even if nothing has been expressed in the contract. I mean, everybody has the right to the eviction. If somebody buy a property, he has the right to request from the last owner, even if it doesn't say in the deed or in the contract.
So you're referring to vacant possession, I'm assuming. That's what that liability for eviction means.
And what's the question?
Article. That's like vacant possession. Our contracts generally offer vacant possession.
Okay.
And if you don't give vacant possession, the buyer can evict whoever is in there.
What is the word? Free?
Vacant possession.
Can you write them in the chat, please, for me?
Not sure if I can do that whilst I'm.
We have a chat here.
Yeah, but I'm not sure if I can find it. Oh yes, maybe I can. Yeah.
Okay, thank you. Vacant possession.
So if vacant possession is not given, the buyer can insist on it and evict whoever is in there.
Okay.
Okay.
So the translation is evict.
Vacant.
Vacant.
Remember, I don't have an American accent. Vacant possession. Maybe an American can tell you how it sounds and what you're used to.
It says it's a legal term.
It means that the house has to be handed over empty. The house has to be handed over with no people living there. Vacant possession.
Yeah. It says that it occurs, no tenant, other occupant, not person belonging, not rubbish. Oh no, but this one comes when, for example, when any kind of tax, with the last owner, they owe some kind of tax. They have the obligation to pay it.
Oh yeah, but I'm talking more about eviction, rather than taxes. We can talk about it later.
Yes. Article 1869, restriction for concluding a sale contract The following are restricted from entering into a sale contract. Number one, spouses cannot enter into a sale spouses cannot enter into a sale contract with each other unless the price belongs exclusively to one of them and the price is paid with the exclusive money of the other. Sometimes they are married. I already told you with separate goods, and they can sell the part that belongs to anyone. But if the ounce are common, they cannot sell the part of the property or the asset. Number two, magistrates, judges, arbitrators, public prosecutors, agent of the public prosecution, official defenders cannot purchase a property involved in case within their jurisdiction. Nor can lawyers, prosecutors, and experts who are involved in the case related to such property. For example, appraisers, notaries, experts, whatever. Also applies to their spouses, ascendants, descendants, and all relatives within the fourth degree. It's against the law. Article 1914, donation. A donation is a contract by which a person called the donor transfers free of charge a part of all the present assets to another person called donee. But the donation, the free donation only can happen with ascendant, descendants, or ascendant or descendant persons. Article 19 and 16. Type of donation. The donation may be pure, conditional, onerous, or remuneratory. Pure donation. A donation is pure when it is made unconditional. 18. Conditional donation. A donation is conditional when it depends on a future event with uncertain realization. For example, there's a lot of examples in the movies. For example, when the donee can acquire the property if he got married with somebody or in any particular situation, something like that. Onerous donation. A donation is onerous when the donor imposes certain burdens, liens on the donee. Any questions here?
Yeah.
Okay. Which one?
In the case of a donation, my understanding is that if I donate a property to my daughter, say, I still have to pay transfer tax and capital gains tax. Is that correct?
No, not capital gains, just transfer taxes.
Just transfer tax. Okay.
Yeah. And the notary fees.
Yeah.
There's no capital gains, neither IVA, is the consumption tax. There's some changing.
I think.
Yeah, wait a second. There's the congressmen in Mexico City, they are proposing just for the city that the donations over 5 million pesos pay taxes. It's a bad news for all the country. That donation over 5 million pesos, it will pay taxes. I hope it doesn't pass. Okay, what is the question? Who was that?
It was me, Dixie.
Dixie.
I think it's a comment and a confirmation from you that it's correct. The reason that there's no capital gains when there's a donation is because the person that it's being donated to, they assume whatever capital gains there might be at the time that there is a sale, correct?
Yeah, it's not a sale, it's a donation, but only applies to ascendant and descendants.
But at the time that the person that receives it, say if I donate my property to my husband,
Yeah,
there's no capital gains. But
No.
at the time that he would sell it, he would be responsible for the capital gains for whatever the value was at the time that I bought it,
Yes.
not him.
Yes, that's right.
Yeah,
And the taxes are
Correct,
gonna be
okay.
calculated from when you bought,
Correct, okay,
not from the
just
donation.
confirming. Correct, okay.
Thank you. Any other question? No? Okay, let's go to the Federal Consumer Protection Law, the law of PROFECO. This law is aimed to at promoting and protecting the rights and culture of the consumer. This law protects the consumer, not the owners, not the providers, the consumer. And to give them certainly equality and legal security in the relationship between suppliers and consumers. What is PROFECO? PROFECO, it comes from the economy ministry. Okay, they come from the economy ministry, federal ministry. PROFECO is a decentralized social service organization with administrative authority functions responsible for promoting and protecting the rights and the interests of the consumer, ensuring equity, certainty, and legal security. PROFECO. And what is the NOM 247? It's a Mexican regulation. ¿Sí? The regulation, the name is NOM, Norma Oficial Mexicana. That means Norma Oficial Mexicana is the official standard, and it's only works in housing, standard for housing that provides protection to the consumers against real estate fraud. Why is the reason of this norm, of this standard? Sorry, it's because there in the past there were a lot of frauds with the buyers, in all Mexico, and more for the person that has Infonavit, that had credit, institutional credit as Infonavit, pensiones, which other Fobiste, etc. There's a lot of institutional credits. So the developers used to make a lot of frauds with them. That's why it comes, and to protect the buyers from the owners, because they used to take advantage on the contract. So the contract has to be registered, or I remember that in the certification course I used the word adhesion. Remember that when I said adhesion, a lot of you doesn't know what is adhesion, but I heard that Derek used the word adhesion. I used to say registered contract, but if anybody knows what is adhesion or adhere, so you can use both. Is the Mexican official standard is of general and mandatory observance for all individual or legal entities that in accordance with the preceding paragraph are directly or indirectly engaged in marketing to the general public real estate intended for residential purposes in the Mexican Republic. So you are very familiarized with this one, the NOM 247. It says avoid sanctions. avoid sanctions. Those involved in the consulting and sale of residential property to the public must contact PROFECO to request registration of their membership contract. Contracts that do not meet the specification of NUM 247 would not be valid. Probably, let's talk about an example. One person or one agent handle a property purchasing, and he doesn't use the PROFECO contract. Okay, probably nobody knows. Probably nobody get noticed that selling. But if the buyer go to PROFECO and give a and ask for a complaint, the PROFECO will go to the owner and to the real estate office, with the broker, and he's gonna give us a sanction, give him a sanction. That is the danger. Okay, they are a standard contract approved by PROFECO, so you can consult them at HTTPS RCL, which is registros de catálogo, etc. profeco.gov.mx. So I'm gonna give you this address. I think everybody knows, but I'm gonna write it in the chat. You'll have it. And you can start the process electronically or physically. I think it's better right now, it's better to go physical to the office, because it takes more than a month to register more than a month to register a contract electronically. But you must try. Also, parties who are developers, builders, promoters, and other individuals involved in advising and selling real estate intended for residential purposes must comply with NOM 247, which became enforceable since September 18, 2022, and PROFECO monitors its compliance. So this is the way it comes. The Ministry of Economy is the boss of PROFECO, and PROFECO brought us the standard 247, and this is mandatory to developers and to brokers. If not, everybody can be sanctioned. What comes in the contract, in the registered contract of PROFECO? The principle they come the 14 rights, of the consumers. Let's read it. I think somebody can help me. You read faster than I. Can you help me? Who, please help me? Alex? Number 1.
Okay, number 1, to receive regarding the offered real estate properties, truthful, clear, and up-to-date information and advertising, regardless of the medium through which it is communicated, including digital media, in a way that allows the consumer to make the best purchasing decision by knowing the true characteristics of the property they are acquiring, in accordance with the provisions of the law. To know information about the characteristics of the property, including the land area, built surface, type of structure, installations, finishes, accessories, parking space, common areas, available services, and the general physical condition of the property.
Yes.
To freely choose the property that best meets their needs and fits their purchasing capacity. not to make any payment until the contractual relationship is confirmed in writing, except for those related to deposits and operational expenses, as outlined by the LEPC, which is the Federal Consumer Protection Law.
Thank you. Well, about the number 3. Why it comes here? To freely choose the property. What happened in the past? The people with Infonavit credits, they went to buy a property and the property is not ready. So they only show a property, an example, como say, casa muestra, as, ¿cómo se dice eso? You know what I mean? Casa muestra, the proof or
Show house.
Demo
Yeah,
house, yeah.
Okay, so they have only the show house, but the house is not ready, the real house. So they choose from the plans, but never see the property, and they have the right to freely choose the property, not the one that the owners say, or probably they can make a cars, like they leave it to like Las Vegas. Oh, this you want this one? No, they have the right to choose. And the number 4, it's about they have the right to they cannot be asked for payment until the contract is ready. The contract is perfectionized, and the contract it is the registered at PROFECO. Number 5, can you help me, somebody, Dixie or Brian, whoever?
All right, I'll do it.
Okay, Vanessa, thank you.
Consumer rights letter for a real estate property intended for residential use. Number 5, to sign an adhesion contract under the model registered with the Federal Consumer Protection Agency, Procuraduría Federal del Consumidor, which includes the terms and conditions of the sale of the real estate property. After signing, the provider is obligated to deliver a signed copy of the contract to the consumer. Number 6, to acquire a
Yes.
property that meets the safety and quality characteristics outlined in the applicable regulations and reflected in the information and advertising received.
Yes. Number
Number
7.
7, to receive the property within the agreed time frame and conditions as stated in the corresponding adhesion contract. Number 8, if applicable, to exercise the warranties on real estate properties provided by the LFPC, considering the specifications outlined in the respective adhesion contract.
Yes.
Number
Number
9,
9.
to receive the corresponding bonus or compensation under the terms of the LFPC in case defects or failures in the property persist after the warranty has been exercised. Additionally, to ensure that necessary repairs are made for defects or failures attributable to the provider, or to opt out for the replacement of the property or termination of the contract where appropriate.
Okay, thank you. Let's discuss first to receive the property within the aged time frame. What happened in Mexico? What the hell happened with the pre-sales? Nobody, zero comply with the times. You know that, isn't it? You already know that. The pre-sales,
I
they
avoid them like
never deliver the property in the time that is contracted. Nobody. So, but we can have, if we have a registered contract at PROFECO, we can defend our rights. We can ask for probably penalization. We can demand something. Okay. Number 8, if applicable, to exercise the warranties. First of all, they are warranties provided by the Ley Federal de Protección al Consumidor, which is PROFECO, considering the specification outlined in the service adhesion contract. I mean, there are rights that you cannot avoid that rights. For example, the structure, the electric and hydraulic installation, and the roof coating, the impermeabilización. How do you say impermeabilización? To protect the roof? The roof.
Impermeabilizante.
Yeah,
It's
that
impermeabilizante.
yeah, but in English.
Waterproofing. Waterproofing.
Okay, that one. So those three things that you can avoid from the contract. You can also write some more rights or guarantees. Sorry. Okay, so but you cannot avoid for them. And number 9, read carefully. To receive the corresponding bonus, they have the right to receive corresponding bonus or compensation under the term of PROFECO in case of defects or failures in the property persist. It means even if the guarantee is off, but they persist. How can you say that it persists? Because you should ask them for reparation before the end of the guarantee. If not, the owner is lost his right. This one. Additionally, to ensure that necessary repairs are made for defects or failures attributable to the provider. So could happen that the warranty is not just 1, 2, or 3, or 5 years, probably more, if they persist. Is that clear? When it's new, okay? Only when the property is new, not in a used property. In a used property, nobody has warranties unless you write it down in the contract. Okay. Number 10. Who can hold me, please?
I'll do it.
Thank you, Christina.
Consumer rights, you're welcome. Consumer rights letter for a real estate property intended for residential use. 10, to have access to free and accessible channels and mechanisms for inquiries, requests, complaints, and suggestions to the provider, and to be informed of the address specified by the provider for receiving notifications. 11, the right to protection by the competent authorities and in accordance with the applicable laws, including the right to file complaints and claims before them. As
PROFECO and others more.
Okay. And then 12, to have access to a privacy notice to understand how their personal data will be processed and to consent to it, if applicable, to ensure that their personal data is processed in accordance with applicable regulations and to know the available mechanisms to exercise their rights to access, rectification, cancellation, and opposition. 13, to receive treatment free from discrimination and to not be denied or conditioned access to housing sales for reasons of gender, nationality, ethnicity, sexual preference, religion, or any other particularity in accordance with the applicable legislation. And 14, to freely choose the public notary for the deed registration process.
Why it says on the number 14, why it says to freely choose the public notary? Because the developers always have all the papers, all the documentation in one particular notary. So sometimes it's hundreds of documents. So they don't want to bring all documents, or the notary that doesn't want to send all that information to another notary. That's why it says that the buyer has he has the right to freely choose the public notary for the deed registration process. That's why it comes here. Any
One
questions?
question
about-
on that, yeah. Is there any geographical limit to that choice? Like, can they choose one in, I don't know, Vallarta, if the property's in Chapala? Okay.
And,
I
and,
didn't
their,
understand.
and their rules
Uh,
are different from ours.
Remember that you can sign your deed anywhere. You can sign the deed here and buy something in Puerto Vallarta, but the notary has the obligation to send and to do the, how do you call, the processing there. But you can always sign your property here. For example, I remember last year I like to work here in Chapala in Najic with the notary of Ramos Uriarte. You know that is number 131. I know, number 15. And but actually there's a new one, number 1, notary number 1 in Chapala is Diego Rodriguez, a friend of me, and he's gonna be a teacher in this diploma course, and he's gonna come with us twice. And you can sign a deed here of a property in Guadalajara, in Tijuana, in Cancun, whatever. But they need to do something there but they have the right. So sometimes I remember I talked with I think with Derek. Yeah, I think with Derek about this person. I don't know, but probably he already died. He was dying. A person he owned a property in Vallarta, in Puerto Vallarta, Nuevo Vallarta, and they have some kind of problems there with the notary. So I asked them, the wife, to send I can handle this property here in Najic, but they never called me back. So probably this person probably passed away. But I offer that option. What is the objectives of? Yes.
Sorry, yes, when I bought my condo in Puerto Vallarta, I had the deed done here. But
Yeah.
what the complication, or it's not a complication, the notary has to agree. They still have to pull the no lien from Vallarta, and then they still have to pay the transmission tax and the registration in Vallarta. So they have to physically go there to do it, or have
Yes.
someone do it.
Yeah, that's right. That's right. But sometimes it's better to go with your notary, with your well, I have a lot of friends, notary friends, no, because I work with taxes. Probably I used to work with 250 notaries in Jalisco and in other states. And for me, it's the same to do whatever. But sometimes about the fees, I can handle the fees with the notary here because they know me, or can help me with the capital gains, with the strategic that I am proposing, or there's a lot of stuff there in the so more in the taxes. I will explain when we are talking about the capital gains today or tomorrow, or Wednesday, sorry. What is the objective of the standard 247? To establish rules, clear rules for all the real estate transactions in Mexico. To eliminate misleading advertising, and action that harm residential property buyers. As a way to ensure that individuals have state license, that's another one. As a way to ensure that individuals have state license to sell a real estate. And not which is the, I'm sorry, this is a quiz. Please help me, which one is the correct? Or which ones? Could be one or two or all. Can you answer this sentence?
I would say all of the above with the except of the licenses, because we're not getting licenses.
No, yeah, that's not the one, the good. So which one is the correct?
The first one.
Yeah, the first
First
one.
and
To
second.
establish, yeah, to establish rule for all real estate transactions. No, it's not the first one.
Yes.
Number two, the second. It says why? Because number one says to establish rule for all real estate. Remember that it's only
Not
for residential.
residential. Yeah.
So number two is the good one. Okay. As a real estate advisor, you must ensure that prospective sellers and buyers sign the following document. Can you help me? Which one? As a real estate advisor, you must ensure that prospective sellers and buyers sign the following documents.
Number 3.
Aquí is not before. Let me. Okay, what is IJA? IJA is an institution. It's a state institution. Yes.
Number 3.
Okay. A privacy notice and lease agreement for the approved listing at IJA. A privacy notice and purchase agreement approved by the Secretariat, Ministry of Economic Development. A privacy notice, clients write letters and adhesion contract registered with PROFECO, or a privacy notice and quotation contract approval by the Secretariat of Labor and Social Work. Which one is the first, the good one?
3.
3.
Excuse
Yeah.
me?
3.
Yeah, number 3. Number 3 is the correct one, the correct answer. Surveillance and verification. The surveillance of compliance with the standard is responsibility of the Secretariat or the Ministry of Economy through the General Directorate of Standards, while verification corresponds to PROFECO, which is responsible for ensuring compliance with the standard, as well as sanctioning any non-compliance with its provision, in accordance with the provision of the law and other applicable legal regulation. So they are surveillance. They are surveillancing, and they can send sanctions to the office, real estate offices. Okay, now this is another quiz. How is compliance with the provision of the standard 247 of PROFECO accredited? How is compliance with the provisions? You have 4 answers. Which one is you think is the correct?
The first.
Yes, the first. The first is the good one. Why? Because number 2, it's about SAT, the Mexican IRS.
Yeah.
The third is about the Municipal Public Works Department, and the number 3 it's about the mechanical rights and services. So the first one is the correct.
No.
Okay, which one is the correct contract? Could be one, two, or everyone's. There are seven type of contracts. Number one, adhesion contract for the sale of real estate intended for residential use. Number two, adhesion contract for the promise of sale of real estate intended for residential use. Number three, adhesion contract for intermediary service for the sale of real estate intended for residential use. Number four, sale contract for land intended for residential use. Number five, adhesion contract for the sale of pre-sale housing. Number six, adhesion contract for the real estate intended for residential house used for FOBISTE beneficiary. And seven, your adhesion contract. Re-adhesion contract for residential. Okay, so the seven are correct. Are you agree with me?
Yeah.
And you're gonna find all of this and more at the catalog in PROFECO. Steps to register my adhesion or my contract. My adhesion contract. Number one, number one, register at the portal as a provider to log in as a user. Number two, choose the nature of the contract. Three, click on view details in my selection. Number four, proceed with the payment to obtain the corresponding folio. Once the registration is granted, the provider will have a contract model with the registration number granted by PROFECO, which can be reproduced as many times as consumers acquire their services. Fill in the spaces. Okay. What happened? Number six, register a new contract model. Number seven, modify an existing contract registration. And number eight, notify the adoption of a standard contract. Let's see how it works. Okay, this is the steps to register my contract. Online at the PROFECO portal. Those are the eight steps, okay? But let's go to the web page. here we have the web page of PROFECO. It's not necessary that all of you have your own contract, okay? Because if you work with a broker, they already have a contract registered at PROFECO, and you can use that one. But you must have a contract between you and the broker, an agreement. Could be an agreement or could be a contract, but you will need a signed contract or signed agreement. The agreement, it only says that you work for that broker, and you can use and you will use the contract of your broker. So here's the page of PROFECO. And first of all, we need to go let me see if we can. If we can have it in English. We can, but let me.
I thought MP had to get a lawyer to do it for us. I didn't think it was available online.
In Spanish, huh? Yeah, but we have
In English.
probably, yeah, we can see in English. Let me find where.
Well, that's what I was saying. We had to get an outside lawyer to do it.
Ugo, I think if you click on the A that's in your browser screen, you might be able to translate from there.
Yeah, no, I can find it. I cannot find it, but we have the tools to see in English. Okay. Okay, first we will go to here we have, it says what is ¿qué es RCLL? It's what is RCLL is the catalog, means the catalog. And then we have here providers and consumers. So we are providers. And first we're gonna need to initiate session and to register ourselves. So register ourselves. And then we're gonna fill the spaces with our name, our the passcode, another again the password and the email. So when you have, let's see. When we oh, where? Here's the mistake. Okay, they send us a message to our email. So now you can continue the registration from the email in your no, it's the well, it's not a real email, so I cannot check that, but you will they're gonna ask you for the identification, an ID, and constancia de situación fiscal, and that's all. And then you will have your username. So when you have the username, we can go to the catalog and see, and we can find our contract. We can find the contract. So the contract is, it comes here, compra, venta de bien inmueble, purchasing of a real estate. And here we can okay, and then they show us a lot of contracts. Purchasing without payment of Canadevi, purchasing of house of Profeco, purchasing of pre-sale of a house at Profeco, purchasing of the land of Profeco, promise of purchasing at Profeco, promise of purchasing of Profeco, etc. There's a lot of contracts. So let's see which and just one. Now here you will how many contracts, and then they're gonna ask for it, and then you're gonna pay for it. It's about 1,900 and something pesos. So let's see the contract. Tricia. Thank you, Tricia. And this is the model. You cannot change anything. Just you're gonna fill the information. If you don't need, there's clauses that it's you have the obligation to fill. For example, the name, the buyer, the seller, etc., the price, the dates, the end lines, etc. No? And how you're gonna pay, etc. But there's you can choose sometimes from one to another. For example, here, in case that you doesn't come with the information with some documentation. For example, structural plans, architectonic plans, installation, etc. Something that you don't need in the contract, because it is a use house, a use property. There's a lot of here is the letter of 14 rights, as right here, rights and obligation. For example, the seller have the right to be paid, and the obligation to give information, to put the information and documents, to not to conditionate the sale about something, etc. No? All the rights we already read. The penalties, you will write here the penalty if somebody doesn't if doesn't if somebody make a fault. The rescission, let's see this, the 13th rescission. What is a rescission and what is a revocation? we have another that is to revoke the sale. It says the number 13, it says it talks about rescission. It says if somebody doesn't comply with or doesn't do the obligation that he already have, you can rescindir, the name, the word in Spanish is rescindir. You can rescind the contract, any part. And let's go to the revocation. In case of if somebody passes away, you put here the disposition, what is going to happen with the money. And let's see. Let me see, where is the revocation? I think it's right here. Here, number 5, to revoke the contract. The buyer part has 5 days. It says 5 days, at least 5 days to cancel the contract without penalization. You cannot avoid from this one. But he has 5 days, it means working days to cancel the contract. He has the right. If he give any money in advance, the seller has the obligation to return the money, all the money, without penalization. And you can bring this to a lawyer that to translate all the information, but you have the buyer and the seller, they need to sign this document in Spanish, and they need to understand. They need to understand in some. They can bring somebody that translate all the information. So it's gonna be legal. And in this part, let me see. Okay, it is the 2021 clause. It says that the model was registered at PROFECO with at the date, any date, and with the number, the number of registration here. So all the contract, you can use this contract a lot of times, anytime you want it. Just you're gonna change the names and some clauses. And also you have some spaces to put to inform that any kind of documentation. If it is new, you need to show to sign with all the information they will need. And here the letter of rights. Here are the 14 rights. Okay. So this is the PROFECO contract. Any question? At 6 o'clock, we're gonna have a break. A break. So let's continue to watching this law. Standard 247. Next. What is the risk? Which are the risks of not having a mandatory registration adhesion contract? A consumer has the authority to report a provider if the mandatory registration adhesion contract is not registered with PROFECO. Registration number and issuance date by visiting the nearest consumer protection office or calling the 800 phone number right here. This is the phone that they can call. And if a complaint is set at PROFECO, they're gonna investigate. The penalty for non-compliance with the provision in Chapter 10 of the Federal Consumer Protection Law, which refers to adhesion contract, can reach an amount of 3 million. That amount are from 2024. 3,157,358 pesos and 71 cents. This amount will be updated annually according to the provision of the law. Any questions here at this time with the PROFECO?
I do a little bit. They're saying that it would be the business that would be sanctioned. Are agents subject to some kind of liability in this case
No.
as well?
No, not the agent, just the broker or the responsible of the office. The office will be
Thank you.
sanctioned with the fine, with this fine.
Understood. Thank you.
Yeah, but if you imagine that, you know what means toco madera? Remember that? What means toco madera? I touch wooden touch.
Yeah, touch wood, obviously. Yeah.
Yeah, it means that I hope it don't happen to your officers or to you. So we in Mexico we say toco madera. So I hope none of you will be penalized with this but if something happened, because I know some brokers of AGIC that have been penalized with PROFECO, with this PROFECO fine. I'm not sure the amount, but I know that two offices in Chapala and another ones in Guadalajara, and I know another one. The fine are millions of pesos. So, but
Okay.
when that happens, if you have your own contract, you can still working with your name, but you will have to comply with. Let me see where let's see the other one. The offices have to compliance the report issued by an inspection unit accredited by the Secretary of Economy. What does it mean? That they will send first the inspector to see if that office or the agent comply with this report. Any more questions? That will happen with the registration and accreditation of real estate agents in Jalisco State, but not now. But they are working. If actually their web page is not working because they have a lot of work. So when I hope when we finish the diploma course, they already fixed the web page. Okay, so let's see now the money laundering law. The name of this law is Federal Law for the Prevention and Identification of Operations Involving Illicitly Obtained Resources. It's the money laundering. Money laundering is the process of concealing resources obtained from legal activities such as drug trafficking, arms smuggling, exotic animal trafficking, corruption, fraud, human trafficking, extortion, piracy, and terrorism. Against this law is to keep the bank system in all countries. So in all the countries have his own law, money laundering law. Knock on wood, Tricia, knock on wood. Thank you. this law provides the placement, arranging, integration, and transferring money of illicit resources. Article number 16, it says that for the purposes of this law, the following will be considered vulnerable activities and therefore subject to identification under the terms of the following article. Number 5 says the habitual or professional provision of construction or development services for real estate. Or mediation in the transfer or of ownership or constitution of rights over such assets involving transaction for the purchase of sale of such properties on behalf of or for clients for whom the services are provided. Such activities will be subject to notification to the SAT. So what are we gonna do? Just to notify to the SAT. That's our obligation. When the transaction or operation is for an amount equal to or greater than the equivalent of either 8,025 UMAS. Which is UMAS? UMAS means Unidades de Medición y Actualización. Well, we'll see this one later in number 32. But we are vulnerable. We are in a vulnerable activity. So we have to be very carefully with this law. Number 11 says that the provision of professional services independently, without an employment relationship with the respective client, in cases where any of the following operations are prepared for a client or carried out in the name of and on behalf of the client. Letter A, the purchase and sale of real estate or the transfer of right over them. B, the management and handling of resources, securities or any other asset of the clients. C, the management of bank accounts, saving accounts, or security accounts. D, the organization of capital contribution or any other type of resources for the establishment, operation, and administration of commercial companies. Or letter E, the incorporation, division, mergers, operation, and management of legal entities or corporate vehicles, including trust, and the purchase of sale of commercial entities. Here. We name, in Spanish, we say umbrales, limits. It's like we have limits. I'm not the word, I don't know what's the word in English for umbrales, but those are edges or limits. So we have limits to use, to pay or to receive a payment of facts or transaction through the use of coins and bills in national currency or foreign currencies and precious metals in the following cases. This is the cash. We cannot accept cash. And those are the reason for this article. We cannot receive more than 8,025 UMAS. Why UMAS? Why not pesos or dollars? No, because UMAS they are actualizing each year. So what we're gonna do is to find out how many pesos worth UMA. Okay. So to transfer the real rights, the limit is 8,025 UMAS, and on the date that the payment is made or the obligation is fulfilled. Probably they can already receive the money, but no more than 8,025. Probably they received this money 1 year ago or 1 day ago, but this is the limit, no more than that. And the establishment of personal rights or of use or enjoyment of real estate for a monthly value greater than the equivalent of 1,605 UMAS. Let's see. personal right of use and enjoyment. What is talking about? They are talking about the of rentals. They are talking about rental because it's personal right of use and enjoyment. So it's in legal languages. So for renting a property, the maximum amount is 1,604 UMAS because the limit since 1,605 UMAS, you cannot receive this amount in cash. And at the last, it says that aforementioned activities shall be subject to notice to the competent authority. I mean, to the SAT, that is the competent authority, when the amount of the act or monthly transaction is equal to or greater than the equivalent of 3,210 current UMAS. Only understand this one. It doesn't say in cash because they can receive this amount in cash, but when it's equal or more than 3,210 UMAS, the realtor, the agent, the broker has to notice to the authorities. How it's gonna be? I'm gonna show you how. Also, you will need to identify your client or user, and where applicable, the controlling beneficiary. Submit notices on the 7th of each month. That the notice that I already told you. Submit the notice on the 7th of each month. For example, if you do the deal on the 1st of a month, you have until the 7th of the next month no, not the current month, the next month, when the transaction exceeds 3,210 UMAS. Remember to designate a representative for compliance obligation in the case of legal entities. When it's a company, you need to have the documentation of a representative to protect and prevent the destruction or concealment of supporting documents for transactions for the next 5 years. The document could be digital, in digital form, and it's not necessary to be in paper. The other one is provide necessary facilities in the event of verification of SAT, and to develop a manual of and also it's better to develop a manual of policies and procedures for the verification and updating of the data provided for clients. This is up to you. This is the way to make the notices. Steps. To submit a notice, you must be registered in the Vulnerable Activities Registry, have your RFSA, Federal Taxpayer Registry, and a valid electronic signature or FIL. Each notice must include details about the act or transaction related to each vulnerable activity. This notice must be submitted no later than the 7th day of the month following, the following month of the operation. For example, if I sell a car for 3,000 pesos, 300,000 pesos on February 14, I will have until March 17 to submit the notice to the SAT. Online, you can do it online at the Money Laundering Prevention Portal. Here is the address, the email. Go to vulnerable activities, that is right here, about here. It's not clear. But this is how it looks. go to vulnerable activities and read the instruction for real estate development, depending on the case. It's important to have the assistance of an accountant by submitting a notice. You are not reporting someone. You just are fulfilling your obligation and security, and you are having the security of your well-being. Well, remember the limits? Well, it's basically provide paying in cash as well as accepting payment for acts and operation through the use of national currency, foreign currency, or precious metals in the following cases. In the sale of a property, the maximum amount will be an equivalent value of 8,025 UMAS. Actually, it's 907,948 pesos using national currency. Foreign currency, you will need to see, but it's in pesos. This information will be in pesos. In the rental of a property, the maximum amount will be an equivalent value of 1,605 UMAS, which is 181,589 pesos using national currency. When the monthly rent amount is equal to or greater than the equivalent of 3,210 UMAS, you must notify to the Ministry of Finance and Public Credit, or to the SAT, which is 363,179 pesos. You have the obligation to notify to the ministry, to the SAT. The UMA for 2025 is worth 113.14 pesos each UMA. Okay. Any question out here? Because we will go to a break. The penalties for violating the money laundering are, the sanctions may include the infractions could be the failure to adequately identify clients or using in accordance with the law and general provision. Number 2, to failure to submit notice in a timely and proper manner. Number 3, to notice submitted with incorrect or incomplete data. Number 4, the notice submitted late, exception applicable as per the second paragraph of Article 53 of the law. Number 4, failure to maintain the administrative file of the client. Number 6, failure to comply with the verification visits and to respond to the request from the authority. And number 7, failure to enforce restriction on the use of cash and precious metals. And the sanctions. Let's see the sanctions. Article 54, it said the applicable fines for the cases mentioned in the previous article of this law shall be as follows. Number 1, a fine equivalent to 200 from 200 to 2,000 days of current general minimum wage in Mexico City. Let me erase this because it is actually is UMAS. We don't use anymore the current this information. Well, it comes in the law, but actually the actual amount is 200 to 2,000 UMAS shall be applied in the case of section 1, 2, and 3. A fine of, let me erase this too. a fine equivalent to 2,000 to 10,000 city, city what? Shall be applied in the case of section. These are for the notaries. This one. Number one is for brokers or agents. This one, number two, is for notaries, and a fine of 10,000 to 65,000 UMAS. It says 10,000 to 65,000 UMAS, or 10% to 100% of the value of the acts of transaction, when quantifiable in monetary terms, whichever is greater. Whichever is greater, I mean, is the bigger one, shall be applied in the case of sections 6 and 7 of the Article 53 of this law. Use the current value of UMA instead of veces salario mínimo. So we don't use times the I don't remember how it calls. Okay, just for last, to end this law, these are the international entities that combat the money laundering in the world. The IMF, International Monetary Fund, FATF, Financial Action Task Force, GAFILAT, Financial Action Task Forces of Latin America, the World Bank, OAS, Inter-American Committee Against Terrorism, United Nations Office on Drugs and Crime, United Nations of Counter-Terrorism, Committee Executive Directory, Asia Pacific Group of Money Laundering, Caribbean Financial Action Task Force, the DEA, Drug Enforcement Administration, Interpol, International Criminal Police Organization, etc., etc. Our world is watching us. So in Mexico is the SAT, and the name is, let me write it down here. SAT and Financial Intelligence Office. So those two are looking forward the money. The way it's because the money leaves some kind of ¿cómo se dice? Rastros, chicos. Steps, no.
Traces?
Yes, that. So all the money brings that in the banks. Our is watching us. So we need to be very careful with the money at the bank. Okay, it's over. The law. If you have any questions, please let me know or write it down, and we will answer it. Let's go to a break. I need a coffee. Thank you. Somebody remember me. I'm gonna stop the recording, so please remember me. Okay, let's see now. It's any question about the last law? No? Now let's see the law that established the registry and accreditation of real estate services providers in the state of Jalisco, or the real estate law. Article number 1, it says the provision of this law are of public order and a social interest and are mandatory in the state of Jalisco. Its purpose is to establish the framework for certifying the knowledge of individuals offering real estate services and for the creation of the state registry of real estate service providers. State real estate registry provides access to information so that users can know that the person they hire, the real estate registry provides information about the agent. So anybody can show and can demand something information or require information and experience and performance in the correct manner. So they can the users can report actually the real estate agents to be erased or punished or sanctioned in this particular law. It says the congressmen approved the law. Lawmakers approved the law regulations in July 21st and 2023. And here is the document. The implementation of a mandate license for brokers and real estate advisors would raise the standard of professionalism. And it's so necessary in our country. It's so necessary, you know. Jalisco is the four state where this law goes very seriously. They have this kind of law in Baja California Sur, in Quintana Roo, I mean in Cancun state. Well, the name of the state is Cancun, is Quintana Roo. In the state of Baja California Sur, where is located Los Cabos and La Paz. Jalisco, and there's another, I remember, Baja California Norte, where is Tijuana, Ensenada, and all that. No? So they ask for this accreditation. The 23 states has a law, states and has the law, but it's not mandatory to be in to be in the registration to show the accreditation. Where is going the law? The law is going in 1 year or two or a couple years to be obligate to the notaries if they're to obligate that any operation need a professional. Will need a professional as in California and all the states in the United States. Article number 3, it says that for the purposes of interpreting and applying this law, the following definition will apply. Number 1, accreditation. It's a certificate. The name is not license. Okay, the accreditation says that it's a certificate issued by the Ministry of Economy in the state of Jalisco that accredits both real estate advisor and real estate agency based on the training up and update they participate in with the aim of ensuring the proper provision of these services. Number 9, unique registry. A list with the names, addresses, and phone numbers of real estate service providers with current accreditation registered in the state of Jalisco. Number 10, real estate service providers, and an individual or entity providing real estate services that holds accreditation and is registered in the state registry of real estate providers in Jalisco.
Hugo, did you just say that this isn't mandatory?
Well, it says the law. There is the article number 1. How to become a real estate agent is a question it's a question many people ask when looking for a job. To be a real estate agent is not that easy, because sometimes, at least in a lot of cities in Mexico, they just order a business card and just they say the name and more. They put broker. They put agent. They order the business card, and the name of sometimes the name of the office is broker. For example, the national brokers of Tlayacapan, for example, no, and they write the name the word broker. They don't understand what a broker is. So, and they don't know anything about, because somebody give them some properties to sell, but they don't know anything about this business. And you know, the state of Jalisco is asking just for 60 hours capacitation here. In other states are 120 hours in the diploma course. So it's not that worse. In Jalisco, they are asking only 60 hours. Sometimes probably some of us could say, "Oh, I already know that. I already know this information." But it's mandatory that we need this course, these 60 hours. So it is important to emphasize that becoming a real estate agent can be a great profession if you enjoy marketing properties and helping clients find or sell their land. There's hay un dicho en México, un refrán, I don't know what the name in English, that says, el que no sirve para servir, pues no sirve para nada, ¿no? O sea, we need to know how to serve another persons. If you enjoy marketing properties and helping clients find or sell their land, house, or commercial space, the first step to becoming a real estate agent is to obtain the necessary education and accreditation. First to know, and then start working. Article 17. To present oneself as an accredited real estate service provider or accredited real estate agency, it is required to hold the accreditation issued by the Ministry of Economy to be registered in the State Registry of Real Estate Service Providers. Article 24. Number one, accreditations shall be valid for next 3 years from the date of issuance, and their renewal may be processed for the same period upon the expiration of their validity. In approximately 1 year, well, I wrote this thing 4 or 5 months ago, sanctions will begin to be imposed on offenders, and access to individual not be involved into the operation will be provided at the signing of this. That is information that sent me off, not from a notary and from SEDEC. Article 32. The failure to comply with the provision of this law and its regulation by real estate agencies and accredited real estate service providers, as well as by those who falsely present themselves as such without authorization, will be sanctioned by the ministry, ensuring compliance with the process. Number 2, when a real estate service provider claims to be an accredited real estate advisor or an accredited real estate agency without being registered in the real estate registry, the ministry will impose sanctions ranging from 50 to 150 the value of the current unit of measurements and update UMass. Let's see how much money is. 150, 50 times. It is 5,000, 5,600. Let me actualize this information. Up to those are the fines. From 50 to 550 times UMass. Transitories, article transitory, and article number 4. The registration in the state real estate registry, accreditation, sanctions, and the corresponding fees will be applicable and enforceable starting the year following the entry into force of this decree. This decree is from June 2024. So it says that in 1 year, so in June 2024, they will start. I'm not sure. Research service providers and agencies currently engaged in such activities must begin the necessary procedure to obtain the required registration and accreditation in accordance with the terms of this decree. Article 18. The ministry shall ensure that real estate providers comply with the following. Number 2, refrain from presenting themselves as an accredited real estate advisor or accredited real estate agency. And number 7, identify themselves during verification or inspection visit and allow their execution, always providing truthful information when required. Note, inspection visit to the real estate agency facilities. Article 13, the ministry shall carry out the inspection visit outlined in this regulation. Article 14, those who violate the provision established in the law shall be subject to the penalty specified in the corresponding article of said regulation. Fine for acting or representing themselves as an accredited real estate agent or accredited real estate agency without being registered in the real estate registry. Suspension of accreditation for a period of 1 year. Harm or infringement of the user interest by real estate agent of agency or agency. Procedure to register in the Registry of Accredited Real Estate Advisors. Well, these are pretty much the images you're gonna see when you go forward. Now, step number 1, go to the portal, Sedeco, blah, 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 blah. Number 2, click on trámites. Number 3, click on consultar ficha. Number 4, click on requirements. So let's go. Let's go to the page. This is the web page, The name is Sedeco, HTTPS Sedeco. I did not write it in the chat. There you have. Okay, we are on the webpage of SEDECO. And I know there's tools to translate all this information. I know, I remember. Okay, first we will go to trámites and services. I have a guide I wrote a guide to do all this. Remember, first step, go to trámites and servicios here. And then we will see this. So we have solicitud de capacitación. This are talking about business. And the number 2 is registro al padrón único de asesores inmobiliarios. Here, the registering of the real estate agent. So we go to consultar ficha. And we have here the requirements. Here are the requirements. The requirements, the format, the steps, the cost. Let me see the cost. Doesn't give information about the cost, but the cost is the 1900, something like that. 2,000 pesos. That is the cost, the price. And let's go to requirements. Oh, here the law. You can see here the information of the law. Here's the law. Ley que establece registro de acreditación. You can download the whole law. Okay, the rules. Here are the rules. And what else? Information, extra information, vigencia. Let's see the requirements, okay? And we have two two pages of information of requirements. Number 1, it says constancia de no antecedentes penales. This is ¿cómo se llama? What's the name of?
It's like a criminal records check.
Yeah,
no?
criminal records. So you will have to apply to criminal records there in Chapala or in Aji. There's an office there. I think it's in the presidential office. Then it says comprobante de capacitación. It will be the diploma. I'm gonna sign the diploma. I will sign, and then the federal registration at SAT, the RFC, and curso pro integridad. It's gonna be another online course. It's very easy, but it's I'm gonna show you all the steps probably you will need some person will need some assistance, but because it's not easy to
Hugo,
follow
can
up.
I make a note? Can I add something on that?
Yes,
I did that course and was told afterwards I was not supposed to do that course. It's for the empresa. It's not for the individual agents, is what they're telling me. So
this
you would
one,
send a copy.
yeah, if you have the this one for you mean what if you have this one for the company, for the
The
agency?
Pro Integridad is a representative from the business needs to do it, not the individual agents. I have that in
Okay.
writing. Because the certificate will not come out with your name on it. It'll come on with the business. And they have told me that individual agents do not do that. You submit a copy of the certificate of the
of the
business.
business. Okay.
Yeah.
Okay. And the person who are independent or just one person, they will need to do the course. And
Sí.
then it comes a photograph. And number 2, identification. It could be the passport, INE, or whatever you have. And then the contrato de adhesión actualizado. This means the PROFECO contract. You will use the contract of the agency and an agreement of the agency with the agent. Okay, but you will need both document, migratory document as your permission, and a proof of address. That's all you will need. Everything will submit online. And this is the all the information, all the steps you will need to process the accreditation, Any question here?
Can you go one slide back, please? After the migratory document, what was the last thing on the list? Yeah, in this
Yeah.
lot.
Let me open. Oh, here,
Is-
this one.
Photograph and what else?
You
Next
will
page.
need criminal records,
Yeah.
the diploma,
Uh-huh.
RFC,
The one we
proof of
don't need.
and a photograph.
Oh,
Okay.
just the photograph. Okay, thank you.
And in the second page, it comes identification, the contract of PROFECO, the migratory, the immigration document, and proof of address. Any question here?
I had a question about the certificate for this course. Carla mentioned the other day in the chat that this is a group diploma. So I was confused as to what that means.
Which one?
Carla mentioned
the
the certificate for this course. She
For this
said that
course?
it is a, yeah,
I will give you a constancia, like a diploma.
I understand, but
That's all.
Carla said that it's a group diploma,
Yeah, it's a diploma.
a group diploma.
No, it's personal. The diploma is
thank you.
personal.
Thank
Yeah.
you.
Thank you. So first, you will go to the link of the ministry or Desarrollo Económico, SEDECO, which call it SEDECO. And then you will go to Trámites y Servicios. We will record at the end of the course, we're gonna repeat this part, okay? And then here, you will go here to the requirements here. And then the requirements. Okay, next one is the federal forfeiture law. With this extension of ownership. When will happen? It refers to the loss of ownership rights over the property without any payment, compensation, or consideration for the owner. The ruling that declares this forfeiture will result in the assets being transferred to the state. This law applies to assets linked to the following crimes: acts of corruption, obstruction of justice, crimes committed by public servants, organized crimes, vehicle theft, resources of illicit origin, money laundering, crimes against public health, like drug-related offense, drug dealers and all that, kidnapping, extortion, human trafficking, crimes related to hydrocarbons, petroleum, gasoline, and all that. This law allows the state to seize and forfeit assets connected to these crimes, transferring them to government control without compensation to the owner. So we need to be very careful when we are renting a property. That's why we recommend to use the contract of justicia alternativa. Probably some of you doesn't know or don't know what is that, the contract of justicia alternativa, but we are going to have a class of the contract, of that particular contract. And specialist will be with us, Felipe Gonzalez, who has an office in Najijic. Probably some of you knows him, Felipe Gonzalez, and he's a specialist in that kind of contract, okay? How can we minimize the risk on these operations? We need, number one, we need to have a document before, is the Google Translator. With a public notary certifying that the acquisition of the asset took place before the illicit act. This can be a problem for individuals who do not have the deed or title of ownership in their name. For example, the property may be intestate without a legal heir designated, but they rent the property without having initiated a legal process. And let's pass this information. Okay. It's important to obtain documented references, guarantees, and bonds, and formalize the agreement with an alternative justice contract that is IJA, that protects the owner or their representative. That is the reason to use the alternative justice contract. Let's read all this sentences. All this information, all these steps is to minimize risk. It says number 2, issue without proper documentation, it becomes difficult to prove legitimate ownership, especially in cases where the property is not formally registered in their name. Solution. It is advisable to regularize the property legal status through the appropriate legal procedures, such as initiating a probate process or obtaining a formal title. Number 3 says, proof that the property was acquired legally. Proof that the property was acquired legally. The deed served as an official documentation to demonstrate lawful acquisition and ownership. Importance. Continuous, public, and peaceful possession is a legal requirement to validate ownership claims, especially in cases where formal titles may not yet be issued. Number 4, verify the authenticity of the contract intended to demonstrate rightful ownership. Public deeds provide legal certainty and are recognized as a valid proof of ownership. I'm trying to find the most important things. It's important here with this law. It's important to do a wise investigation, a professional investigation of the prospect person who is going to rent the property, and keep the information. Could be printed information or digital information. It's important to keep those investigations and do that investigation with proper companies that handle investigation in Mexico. So that way that document will help to show that the owner doesn't have anything with it's not involved with the criminal. So that it's important. We need to investigate also the person who is going to rent the property and the guarantor. Remember that there is three kind of person that will guarantee the rent. Could be we will see that information right here. The general law on security, it's another law, but this is a general law on securities and credit operation. We have three kind of person that can guarantee the payment, the payment of the rent. So which one? The first one is aval, the second one is fiador, and the third one is obligado solidario. The aval is Article 109. It guarantees all or part of the payment of the bill of exchange. That is the endorsement, the aval. The Article 114, the guarantor is jointly and severally bound with the person whose signature he has guaranteed, and his obligation is valid, even when the guarantee obligation is void for any reason. The legal concept of aval is for commercial and applicable to credit instrument, and theoretical not to contract. This go to the aval's name. The aval's word doesn't go with contract. But anyway, the in trials they understand. We can prove that we commit we did a mistake. Fiador. Fiador means a guarantor. Article 2794 to 2855. This is the person who support to the person who will rent the property. This person warrant it's it's a third party is obligated to respond for the debtor's failure to fulfill an obligation, while solidarity is seen when there is a plurality of debtors and creditors. So this is another figure of the law. And the last one is obligado solidario, joint obligor. If you sign a list as obligado solidario, it means that you are obligated to do the same thing that the tenant is obligated to do in the contract. So that they can ask you for the same thing that they would ask the tenant. We can ask for the rent what they rent, just to the tenant or to the obligado solidario. Is this imagine that this is the same person? For example, if there is a tenant and joint obligation in a list, the landlord can ask the tenant and the joint obligor, or only the joint obligor for rent, because he is a joint obligor. So these three names, or these three figures, figures in the law, we need to know for the contract of the leasing operations. Okay, this is the consumption tax law, the IVA law. The new one was published in the Federation by December 1978, the new law. Article number 1 says that individuals and legal entities that within the national territory carry out the following acts or activities are obligated to pay the value added tax or the consumption tax established in this law. Number 1, the transfer when transfer ownership of goods, when provide independent services, when grant the temporary use or enjoyment of goods, and when import goods or services. Article 8. For the purposes of this law, enajenación, that is it's a transfer of ownership, includes, in addition to what is stated in the federal tax code, the federal tax code, we didn't see already the federal tax code. The shortage of goods in the inventories of business. The shortage of goods in the inventory of, it means it's like the accountant says the shortage of goods when it's not anymore in the inventory. So that's called that's called, it's a sale. It's the same as a sale. In this later case, the presumption allowed for evidence to the contrary. The following shall not be considered a transfer of ownership. Number 1, the transfer of property due to death. That is not a sale. Donation, unless made by business for which the donation is not deductible for income tax purposes. Donation, unless made by businesses for which the donation is not deductible. Article 9. The tax shall not be paid on the transfer of the following goods. Land. The land never paid IVA. Structures, number 2, structures attached to the land. For example, that are intended or used for residential purposes. A house will not pay IVA if only part of the structure is used or intended for residential purposes. The tax shall not apply to the part. Hotels are not included in this section. So the land and the houses will not pay IVA. But the hotel, it will pay IVA. Article 15. The tax shall not be paid for the provision of the following services: commissions and other consideration paid by the debtor to creditor in connection with the granting of mortgage loans for the acquisition, expansion, construction, or repair of residential real estate, except those that arise after the approval of the loan or that must be paid to the third parties. 20. The tax shall not be paid for the temporary use or enjoyment of the following goods. The tax shall not be paid for the temporary or use, it means for the leasings. Real estate intended for use or used exclusively for residential purposes. So a leasing of a property for residential purposes doesn't pay IVA. But if a property has multiple uses or purposes, the tax if a property has multiple uses or purpose, for example, commercial facility and in a house, the proportion of the house will not pay IVA. But what happened with a house that it's used as for Airbnb purposes? That if the property comes with furniture, it would pay IVA. If the property comes with furniture, it would pay IVA. Only though doesn't pay IVA if it is empty. And also, if you use the property to lease for any kind of platform, it will pay IVA. Any question here to understand this part?
Hugo, I just want to clarify, are you saying that any residential property, if it is sold furnished, that it could have to pay IVA?
Yes. Just
Okay,
just the property
Just on the furniture.
Yeah, with furniture, they have to pay IVA.
So they'll have to separate out the value of the furniture.
Yeah,
Dollar
but
amount.
yes.
Okay, thank you.
Yeah, you're welcome. Some persons of such agency separate the rent of the furniture and the rent of the property. But if there happen if the SAT do a revision, they could sanction the owner. Article 33. When a good is transferred or a server is provided on an occasional basis for which tax must be paid under the term of this law, the taxpayer shall pay the tax by filing a declaration with the authorized officers within 15 days following the date on which the consideration is received. In the case of transfer of real estate, let's see, when a good is transferred or a server is provided on an occasional basis, okay. And then in the case of transfer of real estate for which tax must be paid under the term of this law, as recorded in a public deed, notary, broker, judges, and other public officials who by legal provision have notarial functions shall calculate the tax under their responsibility and remit it within 15 days following the date at the date the deed is signed. So there's responsible to retain the tax, the IVA. For the purposes of Article 9, Section 2 of the law, asylums and orphanage are considered residential property. It will not be considered as a business. In the case of new constructions, the intended use for which the property was built shall be considered. Article 45. For the purposes of Article 20, Section 2 of the law, when the temporary use or enjoyment of a residential property is granted and is provided, furnished, here is the article is number 45. When is provided furnished, the tax shall be paid on the total consideration, even if separate contracts are entered into for the movable or immobile property. Okay, it means that you can have probably two contracts, but you need to charge IVA when it provide furnished. Any question with this one? It's very clear, isn't it?
I have a question again, Ugo. If it is furnished and you're selling the furniture separately, since we are dealing in real estate, wouldn't we just let the seller and the buyer create a contract between the two of them instead of us managing furniture?
Yes, yes. You can do two contracts, separate contracts, but you have the obligation to charge IVA. It's better.
Okay.
Yeah.
So the office will have to charge IVA on
Yeah.
the furniture. Okay,
Yeah.
and withhold it. Okay,
Yeah.
thank you.
That says the law. So if SAT make some kind of revision check the properties or the documents, if something appears, if you lease a property furnished and don't charge the IVA, they will charge you to the agency or to the owner with sanctions.
Hugo, it's Dixie. I just want to clarify. It furnished, you're talking about furnished, but is it for when you rent or lease a house and also sell one, or just for the rental and the lease?
Yeah, just in a lease.
That's what I thought. So we sell houses that have furniture in them, but the house is a certain price. They don't have to pay IVA on the sale.
No, in the sale, no.
Correct.
It doesn't come in the sale. Remember that in sale, the houses doesn't pay IVA. Just
Okay.
in rent,
Okay.
when you are leasing a property.
I think
Yeah, it's all
by this being
renting.
illegal. So thank you, Dixie, for clarifying that.
You can do two contracts, one for the property and another for the furniture, but you have to charge IVA in both.
That's
Even-
for rental only.
I'm confused.
Me too. Ugo, we have to pay IVA on if the house is a rental and also in the case that the house is being sold furnished?
Yes, you need the article says that you need to charge IVA in the whole rent, not just in the furniture.
That's where everybody's getting confused. When we sell a house, we're realtors and we're selling a house and the house has furniture.
No,
We
no.
don't.
No,
IVA.
and when you're
They're
selling a
only
house, remember, let's go
Right.
back to
They
the
think
other.
It's getting
Yeah.
confusing because everybody on here pretty much just does sales. We don't do rentals. So
Yeah.
everybody's getting confused thinking we're supposed to charge on a sale, but we're not.
Yeah, so yeah,
Correct.
let me clarify. Article 9 says that the tax shall not be paid on the transfer of the following goods. Number 1, land. Number 2, structures attached to the land as the construction. Always when it's a residential purposes. When it's a residential property, it will not pay tax. And this is a transfer of the transfer. It's talking about a sale. But when you are renting or leasing a property, it's different. Here.
Okay, so we don't pay any EVA. There's no EVA that we need to withhold on the sale of a residential home if it's furnished.
Exactly.
Okay, thank you.
Okay. Then Article 43, the federal entities may establish scheduler taxes on the income earned by individuals who receive income from the provision of professional services, granting the temporary use or enjoyment of real estate, the transfer of receipt. Number 3, in the case of individuals who earn income from the transfer of real estate, the tax rate that may be established shall range between 2 and 5%. We're talking about the rate. It's another EVA regulation. This is another EVA regulation. First, we have the EVA consumption tax, EVA law, and now we have it's a completely a new articles from 1 to I don't remember how many, but this is the regulation. All laws have a regulation book. The regulation with, for example, the law for real estate, they comes a regulation, a regulation 1. So this is another one, regulation. The regulation for the EVA law. Article number 43 says that this is very important. This one is pretty important. Let me explain to you. It says, Article 78, for the purposes of Article 33, second paragraph of the law, the persons referred to in said paragraph are exempt from the obligation to calculate and remit the tax mentioned in the stated article when the transfer of real estate is carried out by taxpayers who are required to file monthly tax returns and present stamped copy of the last 3 months tax payment returns. Some notaries doesn't understand this article. When a real estate is not residential, when it is a commercial or any kind, different as a land or residential, they have the obligation to wait a second. They have the obligation to retain EVA, okay, as the IRS, no, not as the capital gains. They have the obligation to retain those 2 taxes, EVA and IRS, capital gains. But remember, when it is commercial, okay, could be a warehouse, could be a shop, could be a fabric, could be a ranch, or unless house and land. So we can ask this to apply this article. But what we're gonna do, but what the notary has the obligation not to retain the tax, which is pretty much, imagine something that worth 5 million pesos. The EVA is 800,000 pesos. So with this, I place as I remember that I am a tax consultant. Okay, so when I have a case of with this particular use as commercial one, I can work to stop the notary to retain the IVA on this kind of sale. But I will clarify when we are on the IRS. Okay, we will remember this regulation in particular. Oh, here the ESR. This is the income tax law or the capital gains. The new law was published in December 11 and 2023. The Article 93 will say us what about the exemption? What happened with exemption? What is an exemption? It's when the law free a contributor to pay the ISR. What is an ISR? It's impuesto sobre la renta, the income tax. This is the income tax law. Okay. The article number 93, it says no income tax shall be paid on the receipt of the following income, and fraction 19, it says that income derived from the transfer of the letter A, taxpayer primary the taxpayer primary resident, provided that the amount of the considered receipt does not exceed 700,000 units, investment units. Those are not UMAs. These are UDIs. The name of these units are UDIs. Write down the UDIs. Okay. So the law allows you to sell properties without payment when the property worth less than 700,000 UDIs. How much would the UDIs worth? The UDIs change every day. Every day change the UDIs. So you need to go to your computer or to your phone and ask Google. Let me ask. You need to ask today. The word today. And it says that be very careful with this, because they show a lot of information. 25 de mayo. Yeah, it's right here. It says that it is, I will write here. Can you prove this information? 8.417615 to see if it is correct. Can somebody look for it? Yeah, I think it's correct. Pretty much very close to correct. So what you're gonna do? You will do a multiplication. 700,000 by it is 5,892,330 pesos. So you can avoid the payment of, I will write it here. You can avoid the payment of 5 million when the property worth 5,892,330 pesos. So you can avoid the tax you will need, you should have to pay until this is the limit. If the property worth more than that, it will be calculated by the notary or by a specialist. Okay, So the the
I've got a
taxpayer won't.
question.
Yes, Alex.
I suppose I've always reacted to the term capital gains tax because my interpretation of 700,000 UDIs is that if you buy a house that's worth more than 5 million, whatever it is, you're not actually being charged capital gains tax. You're just being charged wealth tax. Because it's not the difference between what you paid for it and what you're getting that they're talking about. They're talking about the value of the property being over 700,000 UDIs.
Yes, when the property worth more than 700 UDIs, you can avoid the payment just in this part in 700,000 UDIs. But
Yeah, but
rest,
you might have paid twice that for the house. So why do we call it capital gains tax?
I don't understand pretty much the question. Can you
Okay,
explain it?
so what we're saying is that if you sell a house that's worth more than 700,000 UDIs, which is 5.7 million pesos
Yeah,
or
okay.
thereabouts,
Yeah,
you will pay tax.
Yeah, you will pay tax. It works exactly as in the United States. In the United States, you will pay. You avoid the capital gains.
Well, I don't know about the United
And,
States.
Okay,
Sorry.
it's $250,000. So if the property doesn't worth more than that, you will pay zero in the United States. And if it belongs to two person, you will not pay taxes of when the property.
Yeah, well, I
belongs
get that, but it's not capital gains tax, is it?
No, it's
No.
it's the same.
That's
It
the
works
point
the
I'm
same
making.
here. If
That
the
even if you sell the property, let's say you pay 20 million pesos for it, and you sell the property for 15 million pesos, you will still pay ESEA.
Oh yeah, of course, because there is another
You
there
know?
is another kind of ISR. You are not making a capital gains. You are losing.
That's right.
You are losing. So I will explain in another article. Okay.
Okay, good.
This is just when you have capital gains. When you lose gain, it's another kind of tax.
Okay.
Yeah. Okay. So if you have a property, your example was 20 million pesos. 20 million pesos, let me. It is. It is more pretty much than 2000 and 2 million. No, sorry. I was trying to do it in the calculator. Okay, you have a property that worth 20 million pesos. Okay, so just take away from it 5,892 and 303 pesos from the whole amount, and then the rest of it, I mean 40 million, you will pay the corresponding taxes of that amount. Now, we need to do a special calculate on that. If you're interested, everybody, I can show you how, but it's very hard to calculate that. And that so the article says this article says that the person, the taxpayer, they will not pay capital gains to the houses until that price, which is the price 700,000 UDIs. If the yes.
Can I clarify something real quick? Because this is really a confusing thing for a lot of sellers. Is we use the English word capital gains, but it technically, in Mexico, it's not capital gains. It's a luxury tax, right? Because capital gains is technically you would pay on the difference from what you paid to what you sell. That then you pay on that percentage, right? That's technically capital gains. But here we're allowed that exemption every 3 years up to that amount per seller, right? But over that, they have to pay, but it's technically not a capital gain. It's considered like a luxury tax.
I agree.
We use the word, yeah,
No,
we use the
never,
word capital gains.
I
'cause
never heard that word, luxury gain. For me, as I understand, is capital gain, is the capital that you're gaining on the sale. What if
Yeah,
imagine
but
that
they
you
don't always,
you bought
You're
the
not.
property 10 years ago, you will bring the amount to the present and then make the difference with the price of the sell and the buy on the price of when you bought the property. So for me, I understand as capital gain, not luxury, because luxury saying me
It's
that just for the property with lots and this particular tax applies for any kind of properties.
Even
Right.
if you pay $1 million for it, though, and you sell it for what the point I'm making is similar to what Dixie's saying, because let's say, I mean, there are lots of houses around that sell for 20 million pesos. And if they sell next year for 18 million pesos, they'll still be paying tax.
Sometimes. We will see the
Definitely.
next. We will see the other article, okay? Because you
Okay.
have rights.
Well, if
You have
there's a
rights,
way
you-
around it, I would like
You
to
have
know.
obligation. You have obligations and benefits. So first,
Okay.
the explanation of this article is that, okay? And how are you gonna prove that it's your house? Everybody, the seller have to prove to the notary that is his house and never and he didn't sell a property than the last 3 years.
That bit's the easy bit. Yeah.
Okay, let's see another article. Article 120, individuals who earn income from the transfer of asset may apply the deductions. So remember, you have obligations and you have benefits. This is one benefit. The one benefit is to avoid the payment, to the exemption. Okay. Another benefit is to apply deductions. How will we apply deductions? It comes in the Article 121 of this law. The taxable gains determined after this deduction will be used to calculate the annual tax as follows. Now, number one says that the gain shall be divided by the numbers of years elapsed between the date of the acquisition and the date of transfer, not exceeding 20 years. When exceed 20 years, the acquisition calculate as 10%, 10% of the sale. Imagine that you bought a property 22 years ago, and the actual price you're gonna sell it is 20 million. The acquisition price will go to 10%. So it will be 2 million pesos. The result obtained, number two, the result obtained under the previous section shall be the portion of the gain that will be added to the other taxable income for the relevant calendar year. And number three, they said the portion of non-taxable gain shall be multiplied by the tax, etc. It is how we calculate it, the capital gain. Number 121. Individuals who earn income from the transfer of assets may apply the following deduction. This is very important. Number one, the verified acquisition cost which shall be updated in accordance with Article 124 of this law. In the case of real estate, the updated. So it means it comes to 10%. The updated cash cost shall be at least 10%. When it's more, if you have, for example, if you have a up already you probably you bought a property in 2021, no, 2021 to 2002 in the year 2001. Okay, you bought a property in 1 million pesos and you are selling in 20 million pesos. We will calculate we will calculate the cost in 20%, not in the price you actually bought. I mean, not in 1 million pesos. It will cost 2 million pesos. It says that this article. Number two, the amount of investment made. Here comes the deduction. The amount of investment made in construction, improvements, and expansion when transferring real estate or non-amortizable real estate participation certificate. This investment do not include maintenance. For example, painting or impermeabilization or the garden, whatever you have, it goes to the maintenance. It won't be deductible. Just the improvements. And the number three, it says the notarial fees, taxes, and duties related to acquisition. For example, another important thing here is that since April 1st of 2014, it is requirable that all the deeds comes with the invoice. So if anybody bought a property before April 1st, 2014, they will need the deed and the invoice. If the owner doesn't have the invoice, they be sure that he will pay expensive taxes of it. So don't worry if the deed has the date on the deed is, for example, March 31st, March 30 of 240. Don't worry about it. From that to the past, you don't need the invoice. But from April 1st, 2014, you will need the deed and the invoice of the property. Number three said notarial fees. The notarial fees are the invoice I'm saying about, and duties related to acquisition and transfer deeds. Number 14, commission and brokerage fees paid by the seller related to the acquisition or transfer of the asset. For example, if you are selling a property and you give a invoice to the seller, that your invoice today will help the seller to reduce the ISR. Okay, that was the Article 124. Article 124. Oops, this is in Spanish. It says that I'll show you later. Article 152. This is the schedule, how we calculate the taxes. Article 160. For income derived from the transfer of real estate, the source of this is pretty important for foreigners and Mexicans that doesn't live in Mexico. Remember, when a foreigner buy a property in Mexico, remember that they sign an agreement with the foreigners ministry. Remember that part? So in that agreement, all the foreigners agree that they will be treated as Mexican. So we have the same rights, Mexican and foreigners. We have the same right over this the income tax law. So the Article 160 says, for income derived from the transfer of real estate, the source of wealth shall be considered located within national territory when the property in question is situated within the country. It's not important when we are selling a property, it's not important the nationality of the seller. It could be Mexican or it could be foreign. It's important where he lives. If the Mexican lives in another part, in another country, and he cannot come to sign the deed, they will apply a 20% rate to the total income obtained. The 25% of the total amount of the property worth. Just take grab a pencil, and if the property worth 20 million pesos and the owner cannot come to sign the deed, he will pay 5 million pesos in taxes, 25%. 5 million pesos in tax. The tax shall be determined by applying a 25 rate to the total income obtained. The total income, not a capital gain, just the total income, without any deduction. And he won't have any deduction. And it doesn't matter if it is foreigner or Mexican. The purchaser must withhold the tax if they are resident of the country, foreign resident with a permanent establishment in the country. Otherwise, the taxpayer shall remit the corresponding tax through a declaration submitted to the authorized office within 50 days following the receipt of income. However, what I do as a consultant is the taxpayer who have representative in the country that meet the requirements established in Article 164 of this law, and provide that the transfer is formalized in a public deed in front of a notary, or involves not amortizable real estate participation, may choose to apply the maximum rate. We will go to the maximum rate, which is 35% of the capital gain. It's different. The 35% of the gain obtained than 25% of the total amount of the property. Do you understand this article?
No.
No? Let's
No.
let me explain. I need a new sheet. Let me.
Are you saying that a power of attorney doesn't count in that situation?
Yeah, wait a second. Let me. 160. Okay, I'm gonna erase everything. Let's make an example, okay? The property worth 20 million pesos. If the owner can come to sign the deed, he will pay 25% of the total amount. Which is 5 million pesos. Okay, is that clear there?
Yeah.
It's the article, remember, it's the article 160. Why? because this is because the owner cannot sign the deed. Why? Because he is in Europe, or he is in Japan, or he is in the United States, whatever. Oh, remember, could be Mexican or foreigner. He cannot come to, but he could live. Probably he live power. He lived a power of attorney to somebody to handle the sale. Then in that case, in that case the tax will be 35% of the gains. Which is the gain? I don't know. We need to calculate. Could be, for example, it could be 2 million pesos. 2,500,000. It's an example, okay? This amount. This could be, okay? Imagine that this could be the capital gains. And this is the amount they need to pay. But it's different than 5 million pesos. And here, in this one, let me separate this. $25% of the total amount, and the owner because the owner cannot sign the deed, and no right to deductions. Just have, yeah, they will pay just the 25%, and no, he doesn't have right to deductions. What is the deduction? The deduction are the improvements. Okay. But if he leave a power of attorney to somebody, they can calculate the 35% of the gains, and he or she have right to improvements, deductions. What could happen with the deductions? That this 2,500,000 pesos, 500,000 pesos. Well, this could be, for example, it's an example, okay? Could be you like it better to pay 100,000 pesos than 5 million pesos? It's better, isn't it? Now you understand all this article?
I'm quite fascinated by this because the date that this was decided was 2013, just before all the changes that we felt in 2014. But during COVID, I sold a property for a person who couldn't get to Mexico. The property was reasonably expensive, like not $1 million, not 20,000 pesos, but maybe 18,000 or something like that. And I don't remember having an issue like this. We did actually manage to get a power of attorney, but I don't remember that this complication.
Yes, it's like this. It comes in the law.
Yeah, but I mean, it's been there for a while.
Yeah, and this law comes from 2013. So
Yeah,
we don't
that's what I'm
have
saying.
we don't have changes. So probably
Now,
you didn't.
let's think of another situation. Let's say the
Okay.
person spent 20,000
Okay.
pesos buying the property, and because they're sick and can't come here, they sold it quickly for 16,000 pesos. They didn't actually make a gain at all. Where do we stand there? Do they still have to pay anything over 700,000 duties and tax?
I'm gonna show you something. So where you can see what happened. Okay, wait a second, because I have a program. Okay, let's make an example. Let me know the date that when it acquired the property. It's an example. Give me just information.
We're just making this up as we go along?
Yeah. Yeah,
Okay,
let's do
so
an example.
somebody paid,
No, first the
um,
date, first the date of the acquisition.
I didn't hear that, sorry.
When they acquired the property. Just let's make an example.
2018.
2018. It is a proper. Okay, how many? For how much? How much
9
it was?
million pesos, 9 million pesos.
Okay, 9 million pesos. And you are selling for?
7.5 million pesos.
17?
I know, I better make it different from that, because, yeah, let's say 7.8 million pesos.
7. Okay. With just one seller or how many sellers?
Yeah, just one husband
Okay.
died.
The law for somebody who lives here without exemption, he will pay 1,626,000 pesos. He will pay that. Okay. And just imagine that he's gonna exempt because he lives there in the house. If he can exempt, he will pay 946,000 pesos. But imagine that the owner doesn't live in Mexico. Let's go again. He doesn't live in Mexico.
No, well, nobody's been telling us that. Let's work with the 9 million pesos.
No, excuse me.
No,
You-
I
you-
haven't had an example anywhere where somebody couldn't come to sign the deed and therefore paid 25%.
He can come to sign the deed. Okay.
Okay, well, she
But-
didn't, but yeah.
Oh, she didn't. Okay.
No,
If
we
she
did a power
didn't,
of attorney.
They leave a power of attorney. Okay. But
Yeah.
we go here. Let me see. He lived or she lived a power of attorney. So he goes to this part. He will pay Article 160 with no exemption. He will pay, she will pay 2,362,000 direct with no deductions. This is the Article 160. Oh, sorry. She leaves a power of attorney. So if she leaves a power of attorney, and then we will go to this. See, if she leaves a power of attorney, she will pay more. But here, she have the right to the deductibles. You know that it's different, the calculation. Here we have a person that bought in 2018 for 9 million pesos and are selling for 16 and a half million pesos, and she left a power of attorney. So, but it means that she cannot exempt any kind of tax. She cannot vote in. The 700 ODs, he won't help. So she will pay, in that case, 4,375,000 pesos.
Hugo, question.
Yes.
What if
Dixie.
the seller has lived in the house, has all their receipts, they're a resident, and they're all good, and they have to move out of the house before the closing with the notary, and they leave a week before the closing, and they leave a power of attorney to someone to sign the deed for them, and that power of attorney says that
yeah, he can exempt.
yes.
Yes, okay. Let's go to the
Because
then
he
it
has
would-
lived in the house. They're not living.
Yeah. Yes.
Well, my lady lived in the house as well, but she could only get one dose of COVID, so she couldn't get here. But
If
yeah.
he can check, if he can prove that he lives here and live on a power of attorney, he will pay 946,000 pesos.
a bucket load of money, isn't it?
Okay,
Yeah.
so they're being penalized for not being here to sign at closing, is that what
Yeah.
you're saying?
Yeah, but he can use the exemption, the Article 93. He's not gonna sign it because he leave a power of attorney, but he can exempt the taxes, the capital gains.
Exemption.
Yeah, but in my example, she wasn't making a capital gain. She's lost a lot of money by having
it looks
a
a lot
house
of
that
money.
was
Then-
more than 700,000 duties worth.
No, I just
You're cutting out, Dixie.
and leaves the power of attorney with someone. And they can
Okay,
claim their.
Let's make another example. The property worth he bought the property for 5 million pesos, and he's selling for 9 million pesos, and they are two sellers. And they can exempt the capital gains. They will pay nothing because
Correct.
they can because they're using the exemption.
Right. Well, that's so I just wanted to clarify that. Just because somebody isn't here and they have someone sign the deed for them with the power of attorney, they still have a right to use their exemption if they're resident and they have all their receipts and everything.
Yeah, if he is the precaution to leave a power of attorney in here, then let's change the example. It's only one, the one seller, and he will pay 100,000 pesos. Why? It's only one seller, and
That would be whether
if
the seller was here to sign
if he can
or-
use the exemption, he can use the exemption. Yeah.
Right.
So we need to play with the probabilities or what
I
happens.
think that one of the things we need to do, as well as telling people they need a Mexican will, I think they probably all need a power of attorney, because especially
Yes.
say the snowbirds who come back and forth, they're permanent residents, but they, like, for example, in COVID, they couldn't get back, or I've got one right now where the guy may not be able to travel at all because he's quite sick, but it was their principal place of residence in Mexico. You know, I've never had these complications or differences explained in relation to ESR. I've always just had a blockage when it was called capital gains tax, because it may not be.
Yeah, I understand. Some person from Mexico, they cannot come to Mexico to sign the deeds, so they can go to the consulate in any city around the world, and they can send a power of attorney with the consul, but it means that he is not living in Mexico, so he will pay 25%. So he can send a power attorney,
Right.
sign it on in front of the consul, but it will show that that he will pay 25% of the total amount.
Right.
Why?
Thanks for
Because
the
he doesn't live,
clarification.
he cannot prove that he lives in Mexico, or he didn't live on a power of attorney. If the foreigner didn't live here, the power of attorney, he cannot come to sign one. He can bring a power of attorney of any country, but it means that he doesn't live here, and he will pay 25%. So you need to be very, very, very smart with that.
And it needs to be translated.
Yes.
Thank you.
You're welcome.
Hugo, one question. None of this pertains to Mexican corporations that own residences, correct?
No, when it's you're asking when it's a corporate?
Yes, we have a Mexican
No.
corporation that owns a
Yeah,
property.
when a
dealing with that.
corporate sell a property, it's different, because the notary won't have the obligation to retain any kind of taxes.
Okay, gracias.
Well, thank you. No, you're welcome. Article 164. The representative referred to in this title must be a resident in the country or a foreign resident. This is what is the power of attorney to another person brings. It is a representative referred to the owner. Interpretation: taxpayers, regardless of their nationality, who are unable to prove they resident in the country must pay 25% of the total value of the property as income tax. However, there is a possibility of appointment a representative in Mexico to assume the responsibility for the payments on their behalf. In that case, the tax will be the maximum amount, the maximum 35% rate applied to the gain, but the taxpayer will be entitled to deductions. That is what this article says. Article 200, to calculate the gain on provisional payments, refer to the Articles 120 and 126 of the law, respectively, in the case of income from the transfer of real estate where the acquisition date of the land lost and the land does not coincide with the construction, is when the construction doesn't coincide with the acquisition of the land. Then we need to make two calculations. For example, we're selling a house, but the owner bought the land in one date, and he built the house. And when he's selling, we need to calculate one tax for the land, which will be 0, and one tax for the building. Article 205, for the purposes of the Article 121, Section 2 of the law, when the seller is unable to prove this is important. Remember, this one is very important. When the seller is unable to prove the cost of investment made in construction improvement and expansion of the property, the cost shall be considered as the value stated in the notice of completion of the work, which doesn't exist. So forget of this doesn't exist. When such notice specifies the proportion of the value of investment, so that's why it doesn't exist. Sometimes the notice just notice us they finish the improvement in some date, but doesn't show the worth of the improvement, because they cannot prove the amount of the improvement. Only appraiser or a professional can put prices on the profit. Neither the notaries, only professionals. We can say how many were the improvements. When, for any reason, taxpayer cannot prove the cost of investment in construction improvements and expansion made to a property, they may consider the cost of this investment as 80% of the value of the construction reported by the appraisal. Here is by the appraisal. Perform for this purpose. Who can sign an appraisal perform for this purpose? Only appraiser authorized for this purpose, referring to the date the investment were completed, taking into account the age reported by the appraisal. You understand this one? Is that clear? This example?
Yes.
When the owner doesn't have remember, imagine that you make improvement in some particular property, but when you are selling, you can the notary can take in count this improvement, but it need to be expressed in an appraisal, and who can sign an appraisal? An appraiser authorized for that. We will see in another article. Article 212, for the purpose of Article 126, third paragraph of the law, notaries, brokers, judges, and other public officers who have notarial functions by legal provision are relieved of the obligation to calculate and remit the tax referred to that in that article, when the transfer of real estate is carried out by individuals engaged in business activity. When the person is engaged in business activities, even if he's a physical seller, physical person, or not moral person as a company, is a physical person, he can avoid to pay the retain the tax. Article 217, in all cases of the transfer of real estate, formalizing a public deed where the buyers are individual or legal. Individual, remember, is one person, and legal is a company. Entities referred to the Title 3 of the law, except for those mentioned in Article 86. This is the other Alex. This is the article I was you are waiting for. Article 270. Are you here, Alex?
Yeah.
Okay, let's see. Article 270. In all cases of the transfer of real estate, formalizing a public deed where the buyers are individual or legal entity referred to in the third of the law, except for those mentioned in Article 86, paragraph 4, 5, blah, blah, blah. When the appraisal value, the fiscal appraisal, okay, the legal appraisal exceeds the agreed consideration by more than 10%, the notary brokers, judge, and other public officers who have notary funded by legal provision, when formulating the contract for the transfer in a public deed, will calculate the payment corresponding to the buyer in accordance with Article 132. This calculation will apply 20% to the portion of the appraisal value that exceeds the agreed consideration. Do you understand this one?
Mm-hmm.
Let me put an example. Imagine that your property, you bought the property in 5 million pesos. And last month, okay? And you sell the same property, and you are selling for 4 million pesos. Why? Any reason? You are losing. Your lose are how many? 1 million pesos.
I got disconnected.
The law allows you to when the appraisal no, the amount the appraisal is the legal appraisal, the cadastral appraisal. It looks like it comes with 4 million, 5 million pesos. Okay, this is the cadastral appraisal. And you are selling, to sell is for 4 million. The difference between these two, what is the difference? The difference
Yeah,
is
but that doesn't help.
No?
That doesn't help because of the numbers. If you have a property that's 5 million pesos and you have an exemption of 5.35 million pesos, this doesn't help. The person buying this will have to pay tax on the 500,000 because he's making an instant profit at closing.
Let me finish. When you have this loss in capital, you cannot use the exemption. Okay, you cannot use.
That's why I'm saying this doesn't help, because there's no exemption involved.
Okay.
But if you use much bigger figures, where someone was still losing money, I mean, it sometimes happens, but let's say somebody has spent 10 million pesos and sold for 8.5, and their exemption's only 5 million pesos, then they're going to be paying tax even though they lost 2 million pesos or 3 million pesos in the sale.
Please, tomorrow I will see that example. Please write
Okay.
me down in a message, and we will do.
Okay. Yeah,
Let me
I'll try
finish
and
this
think of the
example.
numbers that work. Yeah.
Let me
Okay.
finish this one. What is the difference here? The property worth 5 million pesos, and you are selling for 4 million pesos, but the appraisal said that it's worth 4.5 million pesos. What is the difference? The difference are 500,000 pesos. So the tax will be 20% of the difference. What is 20% of the difference?
Who pays that?
You will
Isn't
pay
it the buyer who pays in this case?
the buyer will pay this. The buyer will pay 100,000 pesos.
Yeah, the
Okay.
buyer. That's
And
what I'm saying. If you buy for less than the tax value, you expect a tax bill.
Yeah, we will analyze your example tomorrow. But first,
Yeah,
understand
okay.
this one. See, property worth for 5 million pesos, and you sell for 4 million pesos, but the appraisal say that it worth 4.5 million pesos. The difference is 500,000 pesos. Sorry. The law says, the law allows you to sell 10% down under the appraisal. So the difference, what would be? This doesn't come there. This one comes here. Okay, the law allows you to sell 10% under. So the difference will be 400,000. So you will pay 80,000 pesos. The buyer will pay 80,000 pesos.
Yeah, the buyer pays.
There's an example, the real example of what happened when persons sell in a quantity that is under the real price. The real price is the cadastral appraisal, the fiscal appraisal. Okay, is that clear?
Yep.
This example? Anybody
that's
understand
clear.
this example? I will leave there. So tomorrow we'll see. And tomorrow we will start with your example, please, Alex.
Okay.
And for the last, this
You
one is,
mean Wednesday, right?
I want to finish with this, with my favorite one. This is Article 205 of the income tax law. It says Article 205. For the purposes of Article 121, Section 2 of the law, when the seller cannot prove the cost of investment made in construction, improvement, and expansion of the property, the cost will be considered as the value stated in the notice of completion. That I already told never happened. When such notice specify the proportion of the value, never comes with values of improvement or construction. So the taxpayer will consider only the value corresponding to the construction as the cost. When for any reason taxpayer cannot prove the cost the cost of investment in construction, improvement, and expansion made to a property, they may consider the cost of this investment as 80%. Or you can use an appraisal. The appraisals, Article 3rd of the this is of the code. We're right now we're the federal tax code, okay? The federal code, Article 3 says that appraisals carried out for tax purposes shall be valid for 1 year, starting from the date they are issued, for which purpose the tax authority shall accept the appraisals in relation to the assets offered to guarantee the tax in interest of the one. Well, these appraisals refer into the previous paragraph must be carried out by the following appraisers. Who can sign this kind of appraisal? The Institute of Administration and Appraisal of National Asset, the credit institution, public brokers who work in when the Ministry of Economy, and companies dedicated to the purchase. None one of this. The only person that already signed are person. This is an actualization of the law. Person who have professional appraiser license or admit more this title. No, it's not title. It's okay. Somebody help me. You know what is a cédula profesional? It's a document that show that the professional have
Your license number?
no. Well, it's more than a license. When somebody for this license you need to be
Well, in the United
That's
States, you have
need
to
to
have
be-
a
It
number.
shows that you're licensed. It shows that you're licensed and you are registered,
It's
Mhm.
not
Right.
it's
not
not a
that you just got the diploma.
That you got a number.
I never find a transcription of that. To sign this kind of appraisal, you need to be first one of this or lawyer, and after this, and master's degree in appraisers. You need to do this, to be this. You need to be an architect, engineer, lawyer, and you need to have a master's degree. You need to have a degree. No, that's the only person who can sign this kind of an appraisal. Architect, engineer, or lawyer, and
Like about Avalúa,
excuse me.
like the person that does Avalúa.
Exacto. They can sign the avalúo mejor. The name of these are avalúo mejoras. We can sign an avalúo mejoras only
Mhm.
with a master's degree in appraisal.
Okay.
Number 2, association, the group colleagues of appraisal who members have professional appraisal and license, and association, that group expert who have professional appraisal license. Well, I already write a license, but it's not the license, because I can have a license to sign. I can have a license to sign catastral appraisals, and not and I don't need to be a master's degree. You know what I mean? And I can have a license to sign catastral appraisals. It doesn't mean that the engineer or architect have a master's degree. So to sign avalúos de mejoras, he has to be first this architect, engineer, later, and he needs to have a master's degree in appraisal. Well, we're gonna leave it right here. If not, we will continue until hours and hours. Let me